Okay, I think this is the last of this series on discovery and family law. I've chosen, an introductory one, give you some basics and the mandatory disclosure stuff, and the second one, the interrogatories, which are very commonly used in family law, and now the area of depositions, which are also very common. So we'll stop in discovery with this because even the financial affidavit's part of discovery. We've got some work to do there on that. So, moving ahead. So a deposition is a discovery device. It permits oral questioning. There are also written depositions, but honestly, I didn't include that in this lecture. We have interrogatories, and good is good enough. I suppose there might be reasons for some written interrogatory questions, depositions, but I don't know why. At any rate, a deponent is a term, and I use it in this lecture, and I think I used it in the last one on interrogatories too. Technically, a person giving testimony under oath in a deposition. I think it could also testimony in writing and interrogatories. So just wanted to be clear on what my thoughts are. Most of the time, a deposition is taken without leave of court. So the attorneys don't have to ask, the parties don't have to ask the court for permission to depose most deponents, most witnesses. So the parties can be deposed, and other persons that can be deposed are, of course, party, officer, director, or managing agent of a party corporation. So if the thing about employment arrangements, we're talking about a corporation that the party is a part of, not a party corporation. We wouldn't normally have a corporation as a party in a divorce action, so I don't. That's kind of in that idea. This is straight from the rule. And then a partnership or an association or a governmental authority. Medical experts are also an area of deposition. These are the ones that could go without a subpoena and must have a subpoena for former employees and directors. The scope of a deposition is, there are some situations where there is leave of court required. From what I understand in family matters, that only one deposition of a party can be taken, and then you have to get leave of court to take another. This is a good reason why depositions are pushed to, it's kind of a later discovery device after getting the mandatory disclosure, looking at that, getting evidence together, organized, figured out what you don't have or what you do need or what defenses you might need to pull out. But if you've got an imprisoned person, even if it's a party, you would have to get leave of court. If you need to get a deposition other than the number one first of a party, you need leave of court. This is an example of that. I guess I duplicated that. And a minor child. Using the depositions will help determine some more succinct information like identity, location, and content of documentary evidence, the whereabouts of witnesses, and the nature and extent of the deponent's knowledge and expected trial testimony. The benefits are, one of the key benefits is the spontaneity of the deponent. It's not, they're prepared by their attorney, just like you would do in preparing a witness. But they're prepared, but you still get that surprise element, questions that they aren't really expecting, or maybe expecting, but the wording of them isn't as the wording and the body language, the interpersonal part of the communication brings spontaneity to the deponent in terms of answering the questions. That can be both good and bad. Adaptability of questioning. So just like in trial, an attorney can continue with one question and based on the answer, adapt it, dig deeper, go forward, pull out, get the smaller picture or the larger picture. So the adaptability of the questioning is a key benefit. You can discover unfavorable facts, spelled wrong, discover unfavorable facts, commit the opposing party or deponent to specific facts, record their admissions, find out what the deponent does not know, see what facts are behind the adversary's defenses, obtain any information that may be damaging, including admissions, get some valuable impeachment information for the witness, establish a proof of facts, proof of evidentiary facts, lay an evidentiary predicate to the later introduction of documentary evidence. So building a foundation for documentary evidence, and judge the weaknesses and strengths of the case and preserve the testimony, such as if the witness is not available for trial, number of reasons for that. So there you go. The disadvantages, though, they are costly. You'll see that you need a court reporter. If it's an expert witness, you got to pay the expert witness. There's a little fee to some other witnesses that are non-parties, and so that's a disadvantage, is the cost. Another disadvantage is the opposing party now, their attorney can now evaluate the credibility of the client, of the witnesses before trial. And another disadvantage would be they can doctor the wounds left by the deposing lawyer. So they have more time to shuffle it out and see how to present the same thing at trial or at a mediation, arbitration, or settlement negotiations. Oops, what did I just do? There we go. All right, the procedure. This is a short presentation because there's not as much involved in it. I mean, it's a lot of work behind the scenes, but preparing for a deposition is not much. You find your time and place, usually an office or a conference center type of place. Arrange for the person authorized to administer oaths. That would be the court reporter. Send the notices out to the parties. And if you need leave of court, then you would get an approval from the court and get a subpoena. Or just if there's attorneys in Florida have the subpoena powers in some situations, but not all. So then the clerk has to enter the subpoena. Then at the deposition, the officer or court reporter will swear in the witness, and the attorney requesting the deposition asks the witness questions. Opponent may cross-examine, and then all this whole time this is being recorded and by that court reporter, and then when that transcript is done, the record gets reviewed by the witness. Any little changes can be addressed, notations that need to be made, and so on and so forth. To prepare for a deposition in terms of the gathering itself, of course you have your list of questions, you have the exhibits you need, and maybe set up some files for the witnesses' information, assist in preparing the clients, and attend and review the deposition. That might be my last slide. Now, preparing them. Yes, this is an important aspect of the paralegal and lawyer's role when preparing for a deposition, is preparing the witness. First of all, it's unethical to tell a client what to say when they're answering questions. You have to tell your clients to watch for questions that call for privileged information, although that is the attorney's work. Privileged information or the attorney's work product. And, that's something that happens in the moment during the deposition, but, you'll alert the witness that, there might be objections when that happens, to stop answering. So same suggestions apply to all witnesses. Do not have the witness review documents and recorded statements before depositions. changes their memory, changes their initial reaction to the situation, which tends to be more accurate, if that's possible. And there are many, in fact, in the Florida Bar secondary source article that I use to help with these lectures, there's an entire list on there. I recommend you look at the list of questions that they've included, the areas that they might expect to be deposed on. It's a good list. It's a long list too. And also helping them with their appearance. Maybe here's my way of, some people may not be able to answer this if they've never been to church, but I would tell them to dress like they're going to Sunday school. As an adult, and dressed like they're going to church. And in Florida, though, we've got, but no shorts, no flip flops. A man would want you would suggest that a male dress in slacks and a button up shirt if possible, button down all the way, or polo shirts. Not the end of the world. Depends on the role they're playing too. You don't have to be really dressed up, but you want to look professional and clean, so you want to help them with the wardrobe, and to be prepared in that way too, and how they present themselves. And so that concludes this slide deck. Let me see. Now let's look and see